Chapter 12. Custom House Bonds. Sec. 183. In general, many different kinds of bonds are acquired by the Treasury Department of the federal government, in connection with the collection of customs duties on imports. These bonds, for the most part, guarantee the payment of import duties on merchandise, or that the merchandise will be exported out of the country, or that it will be taken to another port and there entered for the payment of duty. There are, however, other miscellaneous bonds, which are required and given in this connection. There are bonds which guarantee that imported merchandise will be used for a specific purpose, which renders it non-dutiable, that merchandise will be held pending an examination by the customs authorities, or that it will be redelivered upon demand of the collector, that certain specified documents will be produced, that damages sustained by the government will be paid, and that the government will be reimbursed for expenses in connection with the importation of merchandise, etc. It appears to be a fact that there have been very few, if any, actual losses under these bonds in the past, and as a class they impose on the surety very little actual hazard, although in some cases there is considerable risk, and in a few cases collateral security is necessary. These bonds are not specifically provided for by any statute, are printed only in book form, can be signed only at the custom houses, and no copies are available. Hence it is difficult for a prospective surety to obtain information, in advance, as to the nature of any obligation of this kind he may be asked to assume. As in the case of internal revenue bonds, it will be my purpose to refer briefly to such of these bonds as are in fairly general use, with special reference to those which seem to involve some considerable chance of loss and to those on which collateral security is necessary. Each form of bond has been given a catalogue number by the Treasury Department, and in order to identify the bond under discussion, the catalogue number will be referred to. In this connection, it is to be borne in mind that if any person, knowingly and willfully, with intent to defraud the revenue of the United States, smuggles or clandestinely introduces into the United States any goods, wares, or merchandise subject to duty by law and which should have been invoiced, without paying or accounting for the duty, or makes out, passes or attempts to pass through the custom house any false, forged or fraudulent invoice, every such person, his, her or their aiders and abettors will be deemed guilty of a misdemeanor, and on conviction, will be fined in any sum not exceeding $5,000 or imprisoned for a term not exceeding 2 years. R.S. Sec. 2865. Any act resulting in a serious breach of a custom house bond would likely come within the scope of this law, and would therefore be punishable by imprisonment. The fear of punishment is always a great deterrent, especially when it is to be meted out by the federal authorities. Sec. 184. Warehousing Bond. Cat. Number 3577 and 3577A. An important and much used class of custom house bonds are those required to be given in connection with the storage of imported merchandise in bonded warehouses. When a man imports merchandise, which he does not desire immediately to dispose of, he is permitted to put it in a public store or a bonded warehouse, and is relieved of the payment of duty until the merchandise is withdrawn, provided, however, that it must be withdrawn, and the duty paid, within 3 years. Every importer, who thus puts imported goods in public store or bonded warehouse, is required to give bond condition that within 3 years from the date of original importation, the merchandise shall be regularly and lawfully withdrawn from public store or bonded warehouse, on payment of the legal duties and charges to which they shall then be subject, or, that at any time within 3 years from date of original importation, they shall be so withdrawn for actual exportation beyond the limits of the United States. As long as the merchandise remains in the warehouse, it may be sold for the payment of duty, and therefore there is no chance of loss as long as the merchandise will sell for enough to pay the duty. The only danger is that before the goods are withdrawn from the warehouse, the market may depreciate, or the goods deteriorate, to such an extent that they will not bring the amount of the duty, and the surety may be compelled to pay a duty which is greater than he can get for the goods. The thing to be considered therefore is the probability that the market for the goods will go down, or that the goods will deteriorate to such an extent that they will not sell for enough to pay the duty. If therefore the merchandise is of a perishable nature, or if it will retain its value only for a season, such for example as Christmas goods imported especially for the holiday season, there may be some risk on the bond, and if the amount involved is large, the bond should not be issued unless the applicant is engaged in a well-established business and is given a satisfactory rating by the mercantile agencies. However, if the goods should so depreciate in value that they are not worth the duty, the owner can enter them for export and throw them overboard. R.S. Sec. 3052, and thereby relieve himself of the payment of duty. If the surety will see that this is done, the maximum liability will be the cost of getting the goods out of the country. And in order that the death or incapacity of the principal may not deprive the surety of this right, it is suggested that, in questionable cases and where the amount involved is large, a power of attorney authorizing the surety's representative to make the withdrawal be required. In case of the actual injury to or destruction of any merchandise by accidental fire or other casualty, while it remains in the custody of the officers of the customs in any public or private warehouse under bond, the Secretary of the Treasury is authorized to abate the amount of import duties accruing thereon, so that no danger need be anticipated from this source. Sec. 185. Bond for warehouse. Warehouses in which imported merchandise may be stored pending the payment of duty, as mentioned in the preceding section, are, under the regulations of the Treasury Department, divided into 8 classes, as follows. Class 1. Stores owned or leased by the United States government. Class 2. Private warehouses occupied exclusively for storage of merchandise owned by the proprietor and entered in bond. Class 3. Warehouses in occupancy of persons engaged in the business of storing dutiable merchandise for hire, and used for the general storage of dutiable merchandise and of unclaimed and seized goods. Class 4. Yards, stables, sheds and stores, which are used exclusively for the storage of animals, wool, coal, lumber, molasses, sugar, iron and other articles, when specifically authorized. Class 5. Bins or parts of buildings used for the storage of imported grain. Class 6. Warehouses for the manufacture of imported merchandise intended for exportation, as provided for by the Tariff Act of July 24, 1897, ch. 11 and the Act of August 5, 1909, ch. 6, s. 23. Class 7. Warehouse for smelting and refining. Class 8. Warehouse for smelting and refining of imported lead-bearing ores or base bullion, under Section 24 of the Tariff Act of August 5, 1909. The government places a customs officer, known as a storekeeper, in charge of each of these warehouses, and it is duty to carry the keys to the warehouse, open it in the morning, close it in the evening and see to it that no merchandise is withdrawn except upon the permit of the collector. And the government requires the owner of each warehouse, except of course those of Class 1, to give bond conditions substantially that he will in all respects comply with the provisions and requirements of the warehousing laws and the regulations of the Treasury Department relating thereto, and exonerate and hold the United States and its officers harmless from or on account of any risk, loss or expense, of any kind or description, connected with or arising from the deposit or keeping or transferring of imported merchandise, including the expense of any kind or description incident thereto, or caused by the transfer of merchandise from the warehouse or premises on the discontinuance thereof as a bonded warehouse, and will also pay to the collector, monthly, the salary of the customs officer in charge of said goods, wares and merchandise, and will promptly report to the collector any and all damaged or perishable articles that may be found in said warehouse, and will not receive any gunpowder or other dangerous or explosive substances, except firecrackers, in said warehouse, and will keep in repair said warehouse, and will not remove, not suffer to be moved, any goods, wares, or merchandise from the warehouse without lawful permit and without the presence of the customs officer in charge. The language of the bond differs slightly in the different cases, but uniformly it contains the provision that the principal shall not remove nor suffer to be removed any goods, wares, or merchandise, from the warehouse without lawful permit and without the presence of the customs officer, and that is the main purpose of the bond, the other obligations being incidental and not at all likely to involve a loss to the surety. And there is practically no probability that he will permit any of the merchandise to get out of the warehouse without a lawful permit, for in the first place, the customs officer has complete charge of the warehouse, and no entry can be made without his consent, and he is a bonded government official who may be expected to perform his duties. In the second place, a penalty of fine and imprisonment is provided by law in case any importer or proprietor of a bonded warehouse, fraudulently or by any contrivance, opens or gains access to the warehouse except in the presence of the proper officer of customs, R.S. 2986, or, in case any warehoused merchandise shall be fraudulently concealed in or removed from any warehouse, R.S. 2987. And in the third place, the principal generally has considerable financial strength. The warehouse itself is generally of quite considerable value, although, of course, it is often mortgaged. However, the equity is usually sufficient to keep the owner straight. In the case of private bonded warehouses, whether used for storage only or for manufacturing, the owners are often concerns of very considerable financial strength and standing. These bonds, though continuous, are, as a class, desirable business. The insolvency of the principal would not necessarily, or even likely, impose any loss on the surety, for the receiver would be required to fulfill the obligations under the bond, and no merchandise could be withdrawn except in the presence of the storekeeper. While it is always well, if possible, to avoid becoming surety for concerns which are likely to become insolvent, yet I believe a surety company would be safe in executing these bonds for practically all applicants. Sec. 186. Bond for storage of imported tea. Cat. Number 3891. A slight variation from the usual warehouse bond is required in connection with the importation of tea, under an Act of Congress of March 2, 1897, entitled An Act to Prevent the Importation of Impure Tea. All tea that is brought into this country must be inspected and passed by United States inspectors before it will be delivered to the importer for sale or consumption. And nearly all tea importers maintain private warehouses for the storage of imported tea, and, pending the examination, they are permitted, by regulation, to remove the tea to their warehouses, provided they shall first have given bond conditioned that no such tea shall be removed or delivered from the warehouse except in pursuance of the collector's permit for the release of tea which has been examined by the United States officers, under the Act aforesaid. The collector of customs does not put a storekeeper in charge of tea warehouses, and it is therefore physically possible for the importer to remove the tea without waiting for the inspection. In practice, however, this is very seldom if ever done, because, in the first place, it does not cost anything to permit the inspection, and therefore there is no incentive for an honest importer to attempt to evade the law, and, in the second place, tea importers, who maintain private warehouses, are generally men of financial responsibility who cannot afford to be dishonest by attempting to import impure tea. In view of the fact that the government does not keep a storekeeper at these warehouses, some companies regard these bonds as involving considerable risk, and direct that they be issued only for concerns having adequate financial responsibility. In practice, applicants for these bonds do have financial responsibility, and so far as I am aware, no one has ever heard of a loss under a bond of this kind. Therefore, I think they can safely be executed for practically all applicants. As a rule, the customs officers are prompt in making the examination of the tea, so that liability under the bond generally terminates within 30 or at most 60 days. Sec. 187. Bond for exportation of impure and unwholesome tea. Cat. Number 3893. We have seen that tea cannot be brought into this country, unless it is examined and approved by United States inspectors, under an Act of Congress of March 20, 1897, entitled An Act to Prevent the Importation of Impure and Unwholesome Tea. When tea is rejected, as being within the prohibitions of that act, the owner is required to give a bond condition that the tea shall be exported without the limits of the United States, within 6 months, and that evidence shall be produced to show the landing abroad of the merchandise and that all custom house charges, which may attach prior to the exportation, shall be paid. In such cases, the importer generally has no alternative but to export the tea, for the customs officials keep supervision over it, so that he probably could not dispose of it in this country if he should desire to do so, and the customs officers, of course, would not permit him to enter it for export without paying the custom house charges. Hence there is very little risk and these bonds may be executed for practically all applicants. Liability terminates within 6 months. Sec. 188. Transportation Bond. Cat. Number 3765. When imported merchandise is stored in a bonded warehouse, the owner may, during the 3-year period allowed for the payment of duty, desire to take it to another port, and may still want to defer the payment of duty. The regulations of the Treasury Department permit this to be done, provided the merchandise be transported in bond. In order that merchandise may be thus transported, it is necessary that it be transported by a carrier that has been regularly designated as a common carrier for the transportation of merchandise in bond, and that the owner give a bond condition that, within a specified time, he will transport the merchandise, or cause it to be transported, by such a carrier, and that he will deliver it to the collector at the port of destination, and that due entry thereof will be made for re-warehousing, and that he will, within a time specified, produce to the collector at the port of withdrawal, the certificate of the collector at the port of destination, that the merchandise has been delivered to him according to law and re-warehoused or the duties thereon paid, or failing to do so, will pay to the proper collecting officer of the United States, at the port of withdrawal, the amount of duties and an additional duty of 100%. When the merchandise is once delivered to the carrier, the responsibility of the owner practically ceases, for his responsibility then becomes secondary to that of the carrier. The risk the surety on the bond of the owner takes is mainly that the principal will not deliver the merchandise to the carrier, but will otherwise dispose of it in order to avoid the payment of duty. However, the merchandise, while being transported from the warehouse to the vessel or cars, is under the supervision of a customs officer, so there is little chance for the principal to divert the merchandise. And inasmuch as any liability would accrue almost immediately upon the execution of the bond, the surety does not have to run the risk of a serious change in the financial condition of the principal, and that is the real hazard involved in bonds where the accrual of liability is deferred. Looking at the matter from a practical point of view, it may be said that almost anybody who is engaged in a legitimate business may be depended upon to comply with the condition of such bond, and they may be executed for all applicants. Bonds of this kind may be cancelled at the end of 30 days. Sec. 189. Bond for Transportation and Exportation. Cat. Number 3837.1. In many cases, merchandise, which is destined for some point in Canada or Mexico, is landed at one of the ports in the United States, and is carried to its ultimate destination either by rail or by a coast steamer. In that event, the payment of duty is of course not demanded, but the owner is required to give a bond condition that, within a specified time, the merchandise will be transported by a certain ship or railroad company, which must have been designated as a common carrier for the transportation of merchandise in bond, and exported to a foreign city, and that, within the same time, the proofs required by law that the said condition has been performed will be deposited with the collector. The risk on this bond is no greater than on a transportation bond. 2 Sec. 190. Bond of carrier for the transportation of merchandise in bond. Cat. Number 3573. In order to obtain the right to transport merchandise in bond, a carrier, whether a railroad or a steamship company, must secure a designation from the Treasury Department and give bond in the sum of $100,000, conditioned that it will duly observe and faithfully comply with the laws of the United States and the regulations of the Treasury Department made in pursuance thereof, pertaining to the transportation and safe delivery of merchandise under sections 3015-6 of the revised statutes and the Act of June 10, 1880, and all acts relating thereto, and shall pay the necessary expenses of such locks, seals and other fastenings as may be prescribed by the Secretary of the Treasury for securing the custody and safe transportation of such merchandise in such cars, vessels and vehicles, safes, trunks, or pouches as may be authorized and used by them for that purpose. and shall also pay the expenses of such inspectors as the Secretary of the Treasury, at his discretion, may cause to be stationed at points along the routes, or upon any car, vessel or other vehicle, such expenses to include the salary as well as the actual necessary travelling expenses of such inspectors, in such manner as may be directed by the Secretary of the Treasury, and shall without delay, transport and make prompt report, by delivery of the manifest which shall accompany the merchandise, and make safe delivery of all merchandise, as described on each and every entry or manifest and in each receipt therefore executed by the carrier or its duly authorized agents, delivered to said carrier for transportation under the provisions of the aforesaid laws, or any of them, to the collector or other proper officer of the customs, to whom the merchandise is consigned in the manifest, in the manner required by law and the regulations aforesaid, or, in default of such transportation report and delivery, shall pay to the United States, as liquidated damages, an amount equal to the value of the dutiable merchandise not so transported, reported and delivered, except where delivery shall have been made to the ultimate consignee or owner, instead of to the collector or other proper officer of the customs, in which case, an amount equal to twice the duties, together with all coster, charges and expenses caused by the failure to make such transportation report and delivery, and shall also protect and save harmless the United States from any loss or damage resulting from fraud or negligence on the part of any officer, agent or other person employed by the carrier. The language of this bond has been quoted at length as the briefest and best statement of the liability and risk of the surety. The essence of the obligation is that the carrier will safely transport the merchandise and deliver it to the collector of customs, who is named as consignee in the manifest. If the carrier is a railroad, the merchandise is required to be carried in bonded cars, that is, cars in which only merchandise in bond is carried, and which are sealed and generally locked by a customs officer at the point of origin and which can legally be opened only by a customs officer at the point of destination. So also if the merchandise is carried in a vessel, it is sealed by a customs officer, the cost of the locks and seals being paid by the carrier. The collector often assigns inspectors along the route of railroads and on board vessels carrying bonded merchandise, and the salary and expenses of such inspectors are to be paid by the carriers. These expenses do not amount to much, and it is improbable that a reputable carrier will deliberately divert the merchandise from the consignee, the collector of customs, and deliver it to the owner or other person. And it is provided by law that in case of an actual injury to, or destruction of, any merchandise by accidental fire or other casualty while in transportation under bond, the Secretary of the Treasury has the right to abate the duty. R.S. Sec. 2984, the principal danger seems to be from an accidental loss not within the scope of this section, or a loss from negligence on the part of the employees of the carrier. The chance of loss by the surety does not seem therefore to be very great, and the only requirement is that the carrier shall be in good standing and in a reasonably good financial condition. This bond is continuous, needing no renewal. Sec. 191. Bond for cartmen, draymen and lightermen. Cat. Number 3855. We have seen that in order for railroad and steamship companies to obtain the right to transport merchandise in bond from one city to another, they must be specially authorized by the Secretary of the Treasury so to do and must give bond. Likewise the regulations of the department forbid that merchandise in bond be carried from one warehouse to another, or to any other place, except by draymen or lightermen who have been licensed as such and who have given bond condition to perform their duties according to the rules and regulations of the Treasury Department relative to the lighterage, cartage or drayage of goods in bond, and to make good all loss or damage that may happen in the handling of any goods from vessels to bonded warehouses or to public stores or from one warehouse to another or to any other place. The obligation of conforming to the rules and regulations of the Treasury Department is not likely to result in any loss under the bond. The principal danger is either that some of the packages will be lost in transit or that the drivers will take some of them. However, this risk has not been found to be very great, and any cartman or cartage company, in good standing and fair average financial condition, would be entitled to this bond. If possible, it should be arranged that the drays for the carriage of small packages be properly screened so as to prevent a theft or an accidental loss of any of the packages in transit. Where the applicant is an importer, who will handle only his own importations, there is practically no risk on the bond, and in that case, the bond may be issued without question. A licensed cartman is to be distinguished from the man who enters into a contract with the government, at specified rates, for the cartage of merchandise in the custody of the government, under Act of June 22, 1874, Chapter 391, Section 25. The bond of such a contractor covers all the liability of a licensed cartman, and in addition, obligates the principal to do the draying at the specified rates. Whether it is profitable or not, the desirability of such a bond should be tested by the principles governing applications for contract bonds. Sec. 192. Bond for delivery. Cat. Number 3775. We come now to a class of bonds on which there is great danger of loss and where the surety should be fully protected by collateral security. The law permits certain articles to be brought into this country free of duty, when they are to be used here only temporarily and for purpose of exhibition. In order that the payment of duty may thus be avoided, the owner is required to give bond conditioned that he will, within 6 months, redeliver the article to the collector of customs at the port of its importation and furnish such proof of its identity as the Secretary of the Treasury, by regulation, may require, and enter the articles for exportation from the United States, within the said 6 months. Although the bond, by its terms, provides that the article shall be delivered to the collector at the port of its importation, it is now permissible to export the article from any port in the United States. See Treasury Decision 31999. This situation affords the importer almost unlimited opportunity to dispose of or secrete the article and refrain from either paying the duty or exporting the article, and, inasmuch as the importers of such articles are generally foreigners, who have no other property in this country, collateral security to the full amount of the bond should be required, and the collateral should not be returned until the surety is furnished with a certificate of the collector that the article has been entered for export and actually exported. Sec. 193. Bond on importation of certain animals for exhibition. Cat. Number 3779. A similar bond is necessary in the case of the importation, free of duty, of those animals on which no duty is required to be paid if they are to be used merely for purpose of exhibition. The bond is conditioned that the importer will, within 6 months from the date of original importation, actually export the animals beyond the limits of the United States and file with the collector the evidence, required by the customs regulations, of such exportation, within 90 days thereafter. This law is availed of principally by Canadians who exhibit their livestock at our agricultural fairs, although it is also taken advantage of by those who desire to exhibit dogs and other animals on the stage. It affords an excellent opportunity to bring into this country, without paying duty, animals which are not in fact intended merely for exhibition, and inasmuch as there is an unlimited opportunity to dispose of the animals without paying duty, and inasmuch as such exhibitors usually have little or no available financial resources in this country, collateral security should be required. In the case of large exhibitions at our agricultural fairs, a customs officer is usually assigned to watch the exhibit while it is here, and if any animals should be sold, as is often the case, the officer, as well as the purchaser, will likely see that the duty is paid. If it is not, the collector of customs, being informed by the officer, would, no doubt, confiscate at least enough of the remaining animals to pay the duty. In such cases, the risk is not as great as when the importer is left to follow his own inclination. However, inasmuch as the principal in such a bond is likely to be a foreigner, from whom it would be difficult to collect any amount the surety might be called on to pay, it would probably be well not to issue these bonds without collateral even where supervision will be exercised by the customs officers, as such supervision will not necessarily prevent the importer from disposing of the stock and declining to pay the duty. Liability on the bond terminates within 9 months from its date. Sec. 194. Bond for exhibition of works of art. Cat. Number 3777. The Tariff Act of August 15, 1909, paragraph 715, provides that works of art, when they are intended for exhibition and not for sale, may be imported free of duty by any state, or by any society or institution established for the encouragement of the arts, science or education, or by any society or association or for a municipal corporation for the purpose of erecting a public monument. In all such cases, the importer is required to give a bond condition that he will not sell, expose for sale or use any of the articles contrary to law and the provisions of the customs regulations adopted in pursuance thereof. The chance of loss under this bond is that the name of some such society or institution will be used as a cloak to enable a speculator to bring in free of duty articles which are intended for sale and not merely for exhibition. The collector of customs would look very carefully to see that the society or institution was not fictitious, that it was in possession of a proper place for the permanent exhibition of the articles, and that the individuals who desire to make the importation are connected in a proper official capacity with the institution. And furthermore, in case of articles of any considerable value, the collector would retain supervision over them until they were permanently located. The actual chance of loss would therefore seem to be small. However, this bond is of unlimited duration, for if the articles should be sold at any time in the future, there would be a breach of the bond. It is doubtful, however, if the customs officers would attempt to trace the articles, although they are at all times subject to examination by the proper officers of customs. The practice with regard to importations under the Act is too limited to admit of anything like a definite statement as to the chance of loss, and it is suggested that considerable care be exercised and that collateral be waived only in very clear cases. Sec. 195. Lay order permit bond or bond for the loading and unloading of vessels at night. In a proper case, the collector of customs will, upon the arrival in port of a vessel belonging to a line designated as a common carrier for the transportation of merchandise in bond, issue a permit for the immediate loading of the vessel, and will grant a special license to load and unload at night. In order to obtain such a license, it is necessary, among other things, that a bond be given, the condition of which is that the principal shall indemnify the United States and the collector from all losses and liabilities which may occur by reason of the granting of the license, and shall pay to the collector promptly a sum sufficient to reimburse the government for the services of the inspector or other customs officers and employees in connection with the loading or unloading of the vessel at night, on Sundays or holidays. R.S. Sec. 2871 and Act Feb. 13, 1911, ch. 46, sec. 6. This bond may, like many other custom house bonds, be given for a period of 6 months, that is, to cover the loading and unloading of all vessels that may be consigned to the principal during that period. And, under the Act of February 13, 1911, it is not necessary for each particular steamship company to give the bond. One bond may be given to apply to all vessels consigned to the principal or for which the principal shall act as owner, agent or consignee, thus enabling steamship agents to give one bond for all lines represented. It is difficult to see how any loss or liability could be incurred by the United States or the collector by reason of the granting of the license, and such liability has seldom, if ever, occurred. The matter of paying for the services of the inspector, in connection with the loading or unloading at night and on Sundays and holidays, is a small expense which, it is believed, has uniformly been paid without resort to the surety, as it accrues at once. It has been the custom to issue this bond for any regular transportation line, and since there is no record of a loss under one of these bonds, there would seem to be no objection to issuing them in the name of the agent, although it would be well enough to look up the matter of the authority of the agent to represent the lines mentioned in the bond. Sec. 196. Bond for delivery of unexamined packages under Section 2899 of the Revised Statutes or the Act of June 30, 1906, or both. Carty, Nos. 3385, 3389. 3393. When there is an importation of any considerable number of packages of the same kind, which come within the scope of the Pure Food Law, Act June 30, 1906, or of Section 2899 of the Revised Statutes of the United States, or both, and are therefore to be examined and appraised by the customs appraisers. The collector usually designates some of the packages for appraisement, and permits the importer to remove the others. He will however require the importer to give a bond condition that he will redeliver the packages, upon demand, within 10 days after the packages so designated for examination shall have been appraised and reported to the collector, and also that, in the meantime, none of the packages delivered as aforesaid shall be opened without the written consent of the collector or surveyor, and then, in the presence of an inspector of customs. If the appraisers find the packages which they examine to be different from what they expected to find, they may require that the other packages be redelivered for examination. In practice, the collector permits only importers of good standing, and whose goods are well known, to remove any of them without previous examination and appraisement, and the result is that seldom, if ever, does the collector find it necessary to recall packages that have been delivered. The demand for redelivery must be made, if at all, within 10 days, so that liability terminates at the end of that period. Such bonds are commonly known as 10-day bonds, and a separate bond may be given for each importation, or one bond may be given to cover all importations during a period of 6 months. Cat. Nose. 3387, 3391, 3395. These bonds may be issued for all applicants. Sec. 197. Bond on export of imported merchandise with benefit of drawback. Cat. Number 4483. When merchandise is imported into this country and then exported, whether in the same form or in a form to which it has been changed by a process of manufacture, the duty that was paid on its importation will be refunded, provided the merchandise has never left the custody of the customs officers, and provided certain other conditions are complied with. The owner must however give a bond conditioned that the merchandise shall not be relanded in any port or place within the limits of the United States, and that the certificates and other proofs required by law, of the delivery of the same at a place without the limits of the United States, shall be produced within a specified time. The most usual case that comes within the scope of this regulation is when raw materials are imported, placed in a bonded warehouse, and then manufactured into a finished product and exported, such exportation being known as exportation with benefit of drawback, that is, with the right to obtain a refund of the duty. The risk under this bond is that the principal will take the merchandise to another port and enter it free of duty, on the ground that it is of American manufacture. But the warehouse is in charge of a government storekeeper, who keeps close supervision over the goods, so it is hardly possible for the principal to violate the condition of this bond. Furthermore, it is hardly reasonable to suppose that a man who is regularly engaged in a manufacturing business, with capital invested, would be likely thus to try to evade the payment of duty when he knows that he will certainly be discovered at the end of the time within which he is under obligation to produce the documents showing the landing of the merchandise abroad, and be compelled to pay the duty and suffer the penalty of imprisonment provided by law. R.S. Sec. 3049. These bonds may be discharged only by producing within a year, if the exportation is made to Europe or America, on within 2 years, if made to any part of Asia or Africa, a certificate of the consignee at the port of destination particularly describing the articles so exported and their actual contents and declaring the name of the vessel from which the same were received, and where the merchandise is consigned to a person on board the vessel. A certificate from the person to whom the merchandise may be sold and delivered may be produced with the same effect as the certificate of the consignee at the port of destination. R.S. Sec. 3044. In addition to such certificate, it is necessary to produce a certificate of the American consul at the port of destination declaring that the certificate of the consignee is true to his knowledge or that it is deserving of full faith and credit. It is also necessary that the certificate of the consignee and the consul be confirmed by the oath of the master and mate or other persons named in the statute. R.S. Sec. 3045. The production of these certificates is not a matter that should concern the surety. If in fact the merchandise was landed at the foreign port, It is not generally difficult to satisfy the Treasury Department, although there may be a technical defect in the certificates. Accordingly, this bond may be issued for all applicants who are engaged in business and are in good standing. Sec. 198. Bond for examination and appraisement of machinery at place of delivery or destination. Cat. Number 3401. In cases where very large and cumbersome machinery is imported, the collector of customs, instead of having it sent to the appraiser's store to be appraised, may permit it to be sent directly to the factory or plant where it is to be used, and, after it is set up there, the appraisers will go there and appraise it. In such cases, the importer is required to give a bond condition that the machinery shall be promptly set up at the place of delivery or destination, at the risk and expense of the principal, and that due notice thereof be given in writing to the collector within 90 days in order that examination and appraisement of the same may be completed, and that the principal shall pay to the United States all duties and charges that may be found due on said machinery, including expenses incurred by the person or persons designated to examine and appraise the same, and that he shall accept the examination and appraisement as in all respects binding and valid. Cat. Number 3401. There is little risk on this bond because such machinery cannot well be secreted or disposed of, so that the lien of the United States for the duty could under almost any circumstances be enforced, without resort to the bond. The collector of customs is prompt in making demand for payment, and there is little or no chance that the owner will have much opportunity, or will attempt, to evade it, and if he should become incapacitated or unable to pay, the machinery could likely be sold for enough to pay the duty. This bond may likewise be issued for all applicants who are in business and in good standing. Sec. 199. Miscellaneous Custom House Bonds. While we have considered the bonds most frequently needed in connection with the importation of merchandise, as well as those on which collateral security is necessary, yet I have not, by any means, mentioned all the different kinds of bonds that may be required in this connection. For example, the regulations of the Treasury Department require that when dutiable merchandise is sent to this country, the invoice must be certified in triplicate by the United States consul nearest the port from which the merchandise is sent, and that the consul must send a certified copy to the collector of customs at the port to which the merchandise is destined. And whenever, from a change of the destination of the merchandise after the production of the invoice to the consul, or from other cause, the authenticated invoice is not received by the collector at the port where the merchandise actually arrives, the collector may nevertheless permit the consignee to make entry of the merchandise upon paying duty on the basis of an appraised value fixed by the customs appraisers, and giving bond condition that he will within 6 months, produce to the collector of customs a duly authenticated invoice of the goods, and pay to the collector the amount of duty to which it shall appear. By such invoice, the goods are subject over and above the amount of duties estimated on the appraisement of said goods. Cat. No. 3379A. So there is the bond to produce a certificate of exportation of American products. Cat. Number 3397. To produce a certain declaration of the foreign exporter of domestic products. Cat. Number 3399. To produce a certain declaration of the absent owner of imported merchandise. Cat. Number 3383. To produce certificate of origin of merchandise from the Philippine Islands, and other similar bonds to produce documents. Cat. Number 3375. Now the purpose of producing such documents is to determine whether or not the merchandise is dutiable or whether the proper amount of duty has been paid. In practice, the customs officers rarely let an article get by unless the proper duty has in fact been paid, so that the bond is a mere form, which, however, must be given in compliance with law and regulations. The production of the document is ordinarily only a matter of detail, and if it should be difficult or impossible, by reason of death or otherwise, the Treasury Department will generally waive its production. There is another large class of bonds required upon the entry of merchandise, or upon its withdrawal from bond for a special purpose which admits, free of duty, merchandise ordinarily dutiable. There is the bond for the withdrawal of salt for curing fish. Cat. Number 3743, for the withdrawal of supplies, for a vessel clearing coastwise, CAT. Number 3879, for the entry or withdrawal of materials for construction or repair of vessels or of their machinery under Section 5 of the Act August 24, 1912, CAT. Number 3755. In all such cases the collector is well satisfied, before he permits the merchandise to be entered or withdrawn from bond, that it will in fact be used for the stated purpose, and makes very little or no subsequent investigation. Where the quantity is unusual or there is anything to excite suspicion, investigation is made in advance. In general, it may be said that with the exceptions noted, Custom House bonds involve very little or no actual risk and that they may be executed with considerable freedom, practically for all applicants. Indeed, it is the very general policy of the companies to waive formal applications and sign these bonds upon the mere request of the importer or even of the custom house broker. And these bonds are needed so frequently, and the amount involved and the individual premiums so small that it hardly pays an agent to go to the custom house so often to sign the bonds, unless, of course, he is handling a large volume of the business. Accordingly, some of the companies give to the custom house broker out to the importer a power of attorney authorizing him to sign the bonds on behalf of the company. In practice this works out satisfactorily and enables the company to handle a line of business on which there are no losses, but which could not otherwise be profitably handled. It is of course unnecessary to add that some discretion must be used in selecting the persons to whom such powers of attorney shall be issued. In this connection it may be well to call attention to the fact that provision is constantly being made by the Treasury Department for new kinds of bonds, and to suggest that any such new bonds, or bonds not referred to in this chapter, be examined to see that they involve no particular hazard. The principal point is to look out for bonds which partake of the nature of theatrical exhibit bonds, that is to say, which provide for redelivery to the collector of customs of merchandise which has been turned over to the importer, free from the control of the officers of customs, and on which, if not so redelivered, an import duty is payable.